Morning. This is the seventh meeting of the Round Ethics Commission for 2025. I'll note for the record that we have a quorum present. And I would, the first item on the agenda is the motion to approve the minutes of the open session held on April 8th, 2025. Is there such a motion?
So moved.
Motion by Commissioner Rabideau, second by Commissioner Susie. Roll call vote, Commissioner Susie.
Aye.
Commissioner Strauss.
Abstain.
Commissioner Browner.
Aye.
Commissioner Callahan.
Aye.
Commissioner Centerini.
Aye.
Commissioner Peterson is absent. Commissioner Rabideau.
Aye.
Commissioner Ritchie.
Aye.
The chair votes aye. Next thing on the agenda is the executive director's report.
Right. Good morning, everyone. So I'll just note, first off, as we always do, that we're live streaming the open session today. The agenda is available on our website for people who are joining us by the live stream. So copies of the draft advisory opinions are available on our website. The live stream will continue throughout the open session, and then it will close while we go into executive session pretty briefly today. I don't expect it only to take a minute or two, and then back to open session again, and the live stream will start. After executive session, we'll report out any votes taken in executive session, and that will also be posted on our website. So then just going down the list on the director's report, most of this pretty brief today. For complaints and investigations, we're still currently at 3 pending complaints. Not really anything to report in any of those 3 right now. Thorson is discovery ongoing. Weston Rogers, we're looking at some adjudication dates. That was a probable cause hearing that we just had. And Jason Licciardi is still under investigation. Regarding advisory opinions, we have 12 advisory opinions pending. Half of them are on today's agenda. So that's, as soon as we work them out, they more come in, but that's good. Then with APRA requests, we've had 6 since the last meeting. We completed all of them within 1 business day, as we always try to do. 3 of those related to complaints and 3 of them related to advisory opinions. So, well there. Financial disclosure, as I'm sure all of you know, the deadline was last Friday for everyone to file their financial disclosure statements. And happy to say that, of course, all ethics commissioners timely filed their financial disclosure statements. Congratulations. Now, for people who hadn't filed their statements, we sent out reminder emails last week. So at the beginning of the week, a reminder email went out. And on the deadline day, we also sent. These reminders only go out to people who haven't yet filed. And those work really well. So as of this morning, and we're still getting some trickle. So the people who file online by the deadline date usually. And then the people who file on paper on the deadline day, we still consider them timely as long as they're postmarked. So they're still trickling in. We had 300 something filings yesterday process. So where are we at? Right now, we're at 85% compliance, which is almost identically consistent with where we were last year on this day, which is a really good thing because last year was our historically fantastic compliance year. So to be right on par with where we were last year means we're on track to hopefully hit 100% compliance again this year, like we did last year for the very first time ever. So we're tracking that. What we do now is, we start working a little beyond just sending emails and friendly reminder letters. Now we kind of release the hounds a little bit. We let the investigators make some phone calls. We start working with town clerks and solicitors, fire district administrators and charter school, heads of school and things to really find out what the issue is. And that usually really helps. So I'll keep you updated on that. One other interesting statistic there, historically, we've been at about 91% of people file online and 9% file on paper. I say historically, but it's moved up a bit each year, but we thought we had kind of stalled a little bit, but this year we made a jump. So right now we're at 92.5%. So I know 1.5% doesn't seem like a big jump, but it really is comparatively. And I think it's probably just an issue now. There are certain people who are never going to file. And they're going to file on paper until they don't have to file any longer, and they'll be replaced by people who file. I've always said that once we get to maybe 95%, 96%, maybe we'll make it manageable. We're subject to an exception, if you really need to file it on paper. We're not there yet. General Office Administration, just note our next meeting is May 20th. So that's going to be the only meeting is on May 20th. Legislative update. So just briefly touch on the two bills that I spoke about that are pending. At the last meeting, I referenced two bills that impact in some way either the Ethics Commission or the Code of Ethics. The first one I want to mention was the House bill that relates to sexual harassment. That was a bill that was introduced, sponsored by Reps Tansey and Agello, that would create penalties for sexual harassment in the General Assembly by members of the General Assembly, their employees, and lobbyists. And it gave the enforcement authority to the Ethics Commission, or would give the enforcement authority to the Ethics Commission. We discussed at the last meeting that maybe the Ethics Commission isn't the best place for these types of complaints to land, that the Human Rights Commission, for instance, might already be more set up for that. But I wasn't really optimistic that the bill, having not heard from the sponsors or anyone, I wasn't optimistic that it was really going to reach momentum this year. And sure enough, it did get scheduled for a hearing before the House State Government and Elections Committee. And that hearing was to be the end of last week. And at the last minute, the sponsors requested that the committee postpone the hearing. So it's currently off the agenda. It's a little late in the session for it to be put back on. So my guess is that we probably won't hear about that again for the rest of this year, but I'll keep an eye on it. The other bill that I'm keeping an eye on and that I brought up last week was a bill in the Senate pertaining to gifts. And that was the bill introduced by Senator Chacon that would raise the gift limits. Currently, it's $25 for top value for an individual gift, up to $75 in the aggregate from the same interested source. Senator Chacon proposed a bill that would take our gift regulation, put it into the general laws, and raise the limits, $50 limit for an individual gift, $250 for aggregate gifts from the same source. So that got called for a committee hearing before the Senate Judiciary Committee on April 8th, I believe. And I went to that hearing as I said I would. Consistent with what I said last week, I tried to limit my testimony to just noting that the Ethics Commission is already taking this issue up, along with another aspect of the gift regulation that we're already knee deep in it, that the Ethics Commission is really the natural and appropriate place to have this conversation, since after all, the gift rule is already an existing regulation of the Ethics Commission. Had not intended to get into the jurisdictional issues that I talked about last time with the advisory opinion that gives primary authority to the Ethics Commission. However, after I concluded my testimony, Senator McKinney had some questions which culminated in him asking me just directly, "You're not suggesting, are you, that we can't do this?" And the way I've always been, whether it's in front of the commission or in front of a legislative committee, is you always tell the truth. And if someone asks you a direct question, you have to answer as directly as you can. And so at that point, I said, well, I hadn't intended to come here to say that, but if that's what you want to know. And then I proceeded to explain the 1992 advisory opinion and offered to provide a copy of the opinion. It was still fine. And you can still view that if you care to. If you're curious, you can go to Capitol TV and watch it. Senator McKinney's point, I think, was that he wanted to make was primarily that he felt that no one's getting bought for $50 or $75 or any of these smaller amounts. He wondered whether it was a good use of the Ethics Commission's time to even worry about investigating small value gifts. My response was, well, we don't really waste a lot of time doing that because we don't have a lot of gift cases on these amounts. And the reason for that is because the gift rule is one of the best parts of the code of ethics. It's very clear, very understandable. We don't have people appealing from violations of the gift rule and claiming that it was void for vagueness or that they didn't understand what was expected of them, like we get with all the other sections of the code. It's a real success. And that was it. The hearing, and it was that bill was held for further study. And I'm not necessarily anticipating that it will reappear, although the sponsor is in the mix for leadership. So who knows? We'll see where that goes. I'll keep an eye on it. Do any of you have any questions about bills or anything else in the director's? Thank you.
Next item on the agenda are the advisory opinions. We're going to take the Honorable K. Joseph Shikarchi first. I am recused on that. Pass the gavel formally.
I don't think I'll need to. Good morning, everyone. The draft for this petitioner is at tab E in your binders. Welcome, Mr. Speaker.
Thank you.
The petitioner is a legislator serving as a member of the House of Representatives. He represents District 23 in Warwick. Originally elected in 2012, he has served continuously since. He is currently serving his third consecutive term as Speaker of the House. In his private capacity, the petitioner is an attorney licensed to practice in Rhode Island. He focuses his practice on zoning and land use permitting, real estate closings, underwriting legal work, business formations, personal injury, and administrative hearings. In February of this year, the petitioner and several other House representatives introduced legislation that seeks to amend existing legislation to establish procedures that would make certain larger parcels of land available for subdivision in order to increase the availability of housing in Rhode Island. If passed, the legislation will expand the ability of cities and towns throughout the state to more readily permit subdivisions of large parcels for housing construction, provided that the proposed subdivisions conform to all other applicable municipal requirements. The legislation has already been considered and approved by the House Municipal Government and Housing Committee and is soon expected to be presented for consideration by the full House. In 2021, the petitioner represented a private client who had applied for a residential zone change in the city of Cranston that would have allowed that client to construct 8 houses on land that he owned, rather than construct only 4 houses as allowed under the city's ordinance. Although the local planning board returned a favorable decision for that client and issued master plan approval, either the city council ultimately denied the application or the application was withdrawn after significant opposition. The petitioner and his client then parted ways. The petitioner explains that their attorney-client relationship existed only for that one case, which lasted for about a year. The former client paid his legal fees in full, and there is no anticipated future business relationship between them. The petitioner states that although the pending legislation could potentially create opportunities for development on the land owned by his former client, the petitioner's review of the city assessor's plat map indicates that will probably not be the case. The petitioner adds that even if the pending legislation were to pass, resulting in the opportunity for the development of land owned by his former client, any applications submitted by the former client would necessitate an independent analysis by the city of Cranston in order to determine compliance with the relevant municipal requirements for development. Cognizant of the Code of Ethics, committed to acting in conformance therewith, and out of an abundance of caution, the petitioner seeks guidance from the Ethics Commission regarding whether he may participate in General Assembly discussions and voting on the proposed legislation. Looking now to the code, a public official may not participate in any matter if it is reasonably foreseeable that there will be a direct financial impact by virtue of the public official's activity upon, in this case, the public official's business associate. A business associate is defined as a person joined together with another person to achieve a common financial objective. The Ethics Commission has consistently recognized an attorney-client relationship as a business association for purposes of the Code of Ethics, and has on multiple occasions required a public official to recuse from participating in matters directly affecting his business associate, or in which a business associate was to appear before the official's public body. Two such advisory opinions are cited in the first full paragraph of page 2 of the draft. However, while the Code of Ethics clearly prohibits a public official from participating in matters directly affecting a current business associate, the Ethics Commission has permitted a public official to participate in matters involving or impacting a former business associate, assuming no other conflicts were present. In determining whether a relationship between two parties constitutes an ongoing business association, the Ethics Commission examines, among other things, whether the parties are conducting ongoing business transactions. Are there outstanding accounts between the parties? Does one still owe the other money? Is there an anticipated future relationship between the parties? Several advisory opinions applying these elements are cited in the draft, beginning in the middle of page 3, extending to the top of page 4. One such example was the subject of advisory opinion 2013-21. There, a member of the State Labor Relations Board, a private attorney, was not required to recuse from matters involving his former law client, provided that the representation had concluded, that all outstanding legal fees had been paid in full, and that there was no reasonable likelihood of reestablishing an attorney-client relationship in the foreseeable future. Here, the business associate relationship between the petitioner and his former law client has ended for purposes of the Code of Ethics. The petitioner states that he represented the former client in 2021 for about 1 year, that the former client paid his legal fees in full, and that there is no future business relationship anticipated between them. Accordingly, based on the facts as represented, the applicable provisions of the Code of Ethics, and prior advisory opinions issued, it is the opinion of staff that the petitioner is not prohibited from participating in General Assembly discussions and voting on the proposed legislation described in the draft, notwithstanding that his former client could potentially be impacted by the passage of the legislation. I'm happy to answer any questions or to defer to House Speaker Archie as you see fit.
Welcome, Mr. Speaker.
Thank you very much.
Have you had a chance to see this, the draft opinion before today? Okay. Do you have any questions or comments for us?
None whatsoever.
Does anyone else have any questions or comments? Okay, do I have a motion to approve and issue the advisory opinion as presented by the staff?
Second.
So there was a motion by Commission, I'm sorry, this is my first time doing this. Oh, my goodness. Commissioner Centarini and a second by Commissioner Browner. Thank you. Okay, we'll have a roll call vote. Commissioner Ritchie,
Yes.
Commissioner Rapidu,
Aye.
Commissioner Centarini,
Aye.
Commissioner Callahan.
Aye.
Commissioner Strauss,
Aye.
and the vice chair votes aye.
Peace.
Did I miss someone?
You missed me.
Oh, see, that's Lauren has done that too. Commissioner Browner, thank you. And so adopted. Okay, thank you.
Thank you very much.
Wish I wasn't that much.
You did all right.
It's ecstatic.
It's back.
It's fun to listen to what you see. And then.
Next item on the sign-in sheet is Perry Kellogg.
Good morning, commissioners. This draft advisory opinion is in this. The petitioner is here today with the legal counsel, Elizabeth Noonan. After receiving the draft advisory opinion last week, the petitioner had requested several edits within the facts. I'll note where they are. I don't object to those changes. They do not change the outcome of advisory opinion. The first change is on page 2. The last sentence in that first paragraph. It starts with the petitioner states this is since its creation, the store has always operated at that location and that her parents initially leased the property was subsequently purchased at 20 years ago. The petitioner is proposing a change where the sentence would read, the petitioner states that since its creation, Seaport Studios has owned the building and operated at that location. Everything else is written. The next change is to the paragraph below it. The first line, the petitioner describes the store building as a 2-story structure instead of 1-story structure. Then the next sentence, the petitioner represents that her parents would like to demolish the existing structure and replace it with a new structure that complies with modern building fire flood code standards, and that includes a new retail space for the business and a single family residence above it where the petitioner and her spouse intend to reside. Remove permanent, just end the sentence after reside. Next one is footnote 1. On the same page, the petitioner explains that architectural review board's members are remove all architects from the sentence and just continue. The architectural review board's members are appointed by the town council. Then to be consistent with the changes made on that page, they should be also changed on page 4. The first full paragraph that starts with here. The third sentence, furthermore, Seaport Studios is owned by the petitioner's parents, and it is expected that if the plans for the new structure are approved, the petitioner and her spouse would live in the residential unit. Remove permanently. The petitioner is a member of the Westerly Planning Board. She has been serving in that capacity since February of this year. The petitioner states that her parents own Seaport Studios, Inc., which is a small business that operates a seasonal apparel and clothing retail store in the Watch Hill neighborhood in the town of Westerly. Plans that the parents are each 50% shareholders in the company. Her mother serves as the corporation's president. Her father serves as its vice president and treasurer. The petitioner does not have any ownership interest in the corporation. However, she's been serving as the corporation's secretary since 2001 and has been employed as its manager for the last 20 years. The petitioner describes the store building as a 2-story structure built in 1890 as a seasonal summer structure and maintained as such throughout the years. The petitioner represents that her parents would like to demolish this structure and replace them with a new structure that complies with modern building, fire and flood code standards, and that includes a new retail space and a living unit above the store. The petitioner states that in August of 2024, on-site engineering, as authorized representative of Seaport Studios, submitted to the town planner a package of pre-application submissions. The petitioner explains that the pre-application process is formal and it is designed to receive feedback without the issuance of any formal decisions by the town. The petitioner represents that prior to her appointment to the planning board, the application was reviewed by the Rhode Island Historic Preservation and Heritage Commission and the planning board. The petitioner also notes that she had appeared before the planning board at that time on behalf of her parents. The petitioner states that a hearing before the town's architectural review board, which is advisory to the planning board, is scheduled for May 1st of this year. And that after that, the Seaport Studios is anticipated to submit to the planning board its application for development plan review, major land development, and unified development for the project. The petitioner represents the she will recuse from the planning board's discussions and decision making relative to those submissions. However, she's seeking guidance from the Ethics Commission regarding what additional limitations, if any, the Code of Ethics poses upon her with regards to Seaport Studios applications or submissions. As we know, under the code, she may not participate in any matter that will have direct financial impact upon her, a business associate, employer, or a family member. She is also prohibited from using her public office or confidential information received through the public office for any financial gain, again, for the same persons, herself, her family members, business associate, employer. She's also required to recuse from participation in any matter if a business associate, employer, or any person within her family appears to present evidence or arguments before her public body. Continuing further with the nepotism provisions, she is also prohibited from participating in any matter if her family members are expected to be party or participant to that matter. And 5E prohibits her from representing herself or others before her. Or those prohibitions last while she serves on the planning board and for 1 period thereafter, and for 1 year thereafter. The Ethics Commission has opined previously that persons of business associates of the organizations for which they serve as either officers or members of the board of directors or in some other leadership position. Here, the petitioner is employed by Seaport Studios and she serves as its secretary. So under the code, she's both employed and a business associate of Seaport Studios. Furthermore, Seaport Studios is owned by the petitioner's parents. And it is expected that if the building is, the new structure is constructed, then her and her spouse are expected to reside there. As a result, the petitioner appropriately anticipate she will be required by the code of recusing in her public capacity from discussions and decision making around Seaport Studios submissions. Upon recusal, the petitioner is prohibited from representing Seaport Studios or her parents before the planning board. Although 5E1 allows the Ethics Commission to grant a public official hardship exception to represent herself, such exception. I'm sorry. Such exception is not extended to or does not exist with regards to representing somebody else before your own ages. The petitioner is not eligible under these circumstances for hardship exception that will allow her to represent herself before her own board, relative to seaport, submissions. While the petitioner may have personal interest in those submissions and in the project, she does not have ownership interest, therefore at this point, she does not qualify for hardship exception. Not only because the petitioner does not have ownership interest in Seaport Studios or the property that is subject to submissions, the submissions made by an attorney or an engineering firm do not constitute representation of her before her own board. Lastly, the petitioner is prohibited from using her public office to obtain confidential information obtained through her public office to gain financial gain for herself, Seaport Studios, or her parents. I'm happy to answer any questions you may have at this time.
Thank you, Ms. Papa. Before I go to the next thing, I simply want to disclose on the record. Ms. Kellogg's parents contacted me probably, I'm going to say 10 years ago for representation. So they are technically a former client, technically a former business associate. I've had no further dealings with them since. So I have no concerns about taking this on today. I just simply want to disclose that. Ms. Newton and Ms. Kellogg, you both had an opportunity to see the advisory opinion, obviously, before it came to us. And you've had a chance to talk to Ms. Papa about it, obviously, at some length. Do you have any questions for the commission or comments you care to make to the commission?
We have no questions for the commission. My only comment is the reason we came to the commission for this advisory opinion is we expect a contested hearing at the municipal level. We wanted to be clear that their recusal was sufficient, and there may be a potential based on, my parents' age, that ownership may change at some point during the process, in which case we know that we will need to come back, depending on what stage of the process we're in.
Anything, Ms. Kellogg?
No further comment. Thank you.
Commissioners, anyone have any questions or comments? Commissioner Rabideau?
The petition speaks to the architectural review board and a hearing coming up on Thursday. She's not prohibited from giving any testimony before that board because she has no, she's not an appointing authority and it's not her board.
That's technically correct. The architectural review board is advisory to the planning board. So out of abundance of caution, I would suggest that she does not appear before them, although under the code, she is not a member of that board and she's not appointing authority of that board.
Is that okay for your client?
Sure, and just understand normally that architectural review board process occurs in Westerly before the pre-application process. Both myself and the planner were sick that day, and so it really the hearing never got off the ground. We had the pre-application prior to Ms. Kellogg being appointed to the planning board. We're going ahead with it on Thursday, but she can officially recuse if that would make it better.
She's not on it.
Oh, no, that's right. I'm sorry.
My question was to
Not-
get testimony.
Not testimony. We have, honestly, it's architect to architect. So we have our architect president at that hearing. I sit back, we let the architects do the work. So we'll have Perry not speak at that hearing, but she can she attend? Can she attend?
Absolutely, she can attend that.
Okay.
Unless I'm mistaken, she's entitled to attend any public hearing.
Public hearing, correct.
You just can't participate. It's member, anybody can go. Any other questions, comments?
Yes,
Commissioner Ritchie?
your letter to the commission, I'll refer to page 3, your letter, please. On the building, seeking a hardship exception
May I answer that,
here.
Richard?
Yes.
We were not sure whether or not we needed a hardship exception. In reviewing the draft and in my discussions with Attorney Papa, it does not apply unless we have an ownership interest, which we do not have at this time. Ms. Kellogg does not have. it.
Any other questions or comments? Is there a motion to approve and issue the advisory opinion as amended? Staff as presented this morning.
So moved.
Commissioner Bronner, motion, Commissioner Rabideau, second, I believe.
Either way.
That's pretty close. Commissioner Ritchie motion.
I got the R's.
Commissioner Rabideau second. A roll call vote. Commissioner Susie.
Aye.
Commissioner Strauss.
Aye.
Commissioner Browner.
Aye.
Commissioner Callahan. Aye. Commissioner Centerini. Aye. Commissioner Rabideau.
Aye.
Commissioner Ritchie. The chair votes aye. Thank you very much.
Thank you so much for your time.
Next item on the sign up sheet is Megan Riley. Morning.
Hello again, the draft, this petitioner is at tab C in your binders. Welcome, Ms. Riley.
One moment. Commissioner Callahan will be recusing on this matter. Patience.
Thank you. Ms. Riley was elected to the North Kingstown School Committee last November. In her private capacity, she is employed by Effective School Solutions, or ESS. ESS is a national service that provides substitute teachers and administrators to schools throughout the country. ESS currently has a contract with the town of North Kingstown that is expected to expire this June. The petitioner has been employed by ESS since 2022 and is currently working as a substitute teacher in the North Kingstown School District. She has asked for this advisory opinion to determine whether she is prohibited by the Code of Ethics from continuing to work as a substitute teacher in North Kingstown while simultaneously serving as a member of that town's school committee. Since 2022, the petitioner has worked as a substitute teacher approximately 1 to 2 days per week during the school year for grades preschool through 12. She does this under ESS's contract with the North Kingstown School District. Ms. Riley emphasizes that she is not an employee of the town and that she is paid each week directly by ESS. She adds that she has a supervisor at ESS who serves as an intermediary between her and the school district as necessary. She cites potential examples, an issue with her pay or the occurrence of an incident at one of the schools in which she may have been a party or a witness. Petitioner's job performance is not monitored by the school department, nor does she receive reviews from the school department. There has been no interruption in the petitioner's employment with ESS since her start date. Looking now to the code, Regulation 1.5.4, one of the municipal revolving door regulations, prevents any municipal elected official or school committee member, whether elected or appointed, while holding office and for a period of 1 year thereafter, from seeking or accepting employment with any municipal agency in the municipality in which that official serves. For this particular regulation, part-time service as an independent contractor is included in the definition of employment. There is an exception if the elected official or school committee member held the appointment in question at the time of her election to office, and there has been no interruption in that employment. Here, the petitioner's employment with ESS was held at the time of her election to the school committee. Furthermore, it is ESS and not the petitioner that is providing services as an independent contractor to the town. Therefore, it is the opinion of staff that the provisions of Regulation 1.5.4 are inapplicable to the petitioner here. Accordingly, it is further the opinion of staff that the petitioner's continued employment by ESS as a per diem substitute teacher in the North Kingstown School Department while she simultaneously serves as a member of that town's school committee is not prohibited. However, while the petitioner may continue to work as a substitute teacher in the district, the other code provisions referenced in the draft as relate to conflicts of interest and required recusal do prohibit her from participating in any school committee matters that will financially impact her private employer, ESS. She is also required to recuse if and when ESS or its authorized representative appears or presents evidence or arguments before the school committee. This includes her recusal from discussions and decision-making during the school committee's consideration of whether and under what terms to renew its contract with ESS. Finally, the petitioner is reminded that Regulation 1.5.4 prohibits her from seeking or accepting employment from the North Kingstown School District or any other municipal agency in North Kingstown during her tenure on the school committee and for a period of 1 year thereafter. I'm happy to answer any questions or to defer to Ms. Riley as you see fit.
Morning, Ms. Rowland.
Morning.
You've had an opportunity to speak to Ms. Ridiculous about the opinion.
Yes.
Do you have any questions, comments, concerns about it?
No.
Members of the commission, anyone have any questions? Commissioner Ritchie.
Does the town pay ESS?
Yes.
Are you paid as a member of the school committee?
Yes.
I'll refer to you now. You see that as a problem?
Pardon?
You see that as a problem?
I do not.
Tell me why you don't see that as a problem.
They're two separate things. The problem would be is if after being elected to the school committee, Ms. Riley accepted a position with the town to serve as a teacher. ESS is her private employer. It is her private employer that has a contract with the town of North Kingstown. That she is compensated for her service as a school committee member. I'm failing to make a connection. I
No,
apologize.
I'm just looking at the fact that she's being paid twice, one through ESS and then through the town as a member of the school committee.
Right.
But the town is also paying ESS. So in essence, she's receiving money from, say, the town for both purposes. You don't see that as a conflict?
I do not for this reason. It's because, well, we understand there's a stipend for serving on the school committee.
Still being paid. by the
Yes.
town.
Yes, for her service on the school committee. As to her substitute teaching, if the town was paying her directly, we got a problem. The town is paying her private employer, ESS.
You don't see that connection?
I do not, nor does the code, Commissioner Ritchie.
Okay.
Any other questions and comments? I do have just one. The school district has the contract with ESS, correct?
Yes.
If I understand the opinion correctly, I want to make sure you understand. If ESS comes before the school committee looking for a change in its contract arrangement, that you have to recuse from that.
Yes.
You understood that?
Oh, yes.
That's the one thing that struck me is that you've got this issue that could come before you. They get compensated for their full contract. And that will be,
Yes.
anyone else have any questions at this point?
By the same token, it's the aura. concerned.
Yeah, I think, I understand your question, Richie, but I think she's, yes, you want to say something?
Oh, no, I wasn't there. Sorry.
Is there a motion to approve and issue the advisory opinion as presented by the staff today? Don't move.
Second.
I believe that was Commissioner Centerini's motion. And Vice Chair Susie's second. A roll call vote, Commissioner Susie.
Aye.
Commissioner Strauss. Aye. Commissioner Browner. Aye. Mr. Callahan is recused. Commissioner Centerini. Aye. Mr. Rabideau.
Aye.
Mr. Ritchie.
Nay.
The chair votes aye. Thank you.
Thank you very much. Thanks for coming in. That has been the system. Nice to meet you. Appreciate your help.
The next item on the sign-in sheet is Laura Pickering.
The draft for Ms. Pickering is at tab F, your binder. Welcome, Ms. Quigley. Petitioner is an attorney. Oh, I bet.
No.
Have that. The petitioner is an attorney in private practice who was previously employed by a law firm that represents approximately 12 school districts in Rhode Island. She requests an advisory opinion regarding whether she is prohibited by the Code of Ethics from representing clients in special education disputes against school districts in municipalities represented by her former employer. The petitioner's former law firm provides these services on a contractual basis, and the attorneys from that firm are not sworn in as solicitors by those municipalities. Petitioner believes that the law firm bills each municipality for its services and receives a Form 1099 in return every year for income tax purposes. When speaking with the petitioner earlier, she has asked that I make one slight edit on in paragraph 1 following the response on page 1 at line 4. It currently states the petitioner explains that the law firm bills each municipality for its services and receives a Form 1099 in return each year for income tax purposes. She has asked that I replace the word explains with believes. She just wants to be certain about that. The petitioner was employed by the law firm as an associate attorney from July of 23 through January of 2025. Her duties as an associate attorney included in large part providing support to the partners by conducting legal research, drafting legal memoranda. Not long before she left the law firm in January of 2025, the petitioner attended a school committee meeting in one of the school districts as a substitute for a partner of the law firm who was unavailable to attend. In November of 2024, she attended 2 school committee policy subcommittee meetings in another school district for the same reason. The petitioner now maintains her own law practice. She would like to represent clients in special education disputes against school districts, which may include those that are represented by her former law firm. Petitioner specifies that she wishes to represent the parents of special education students in individualized education program or IEP meetings and in other various education matters within the school district. She emphasizes that appeals from the decisions of IEP meetings are made to the Rhode Island Department of Education. She notes that none of the matters involving clients with children in a school district would require her to appear before a school committee. It is in the context of these facts that the petitioner seeks guidance regarding whether she may represent clients in special education disputes against school districts in municipalities that are represented by her former employer. As a threshold determination, the Ethics Commission must ascertain whether the petitioner in her former role as an attorney with a law firm that provides legal counsel to multiple school districts was subject to the Code of Ethics. If she was, she will remain subject to the revolving door provisions for a period of 1 year following the severance of her position with the law firm. Pursuant to Rhode Island General Laws 36-14-4, the following groups of individuals shall be subject to the Code of Ethics. 1, state and municipal elected officials. 2, state and municipal appointed officials. And 3, employees of state and local government, of boards, commissions, and agencies. Unlike solicitors, who are municipal appointed officials with duties set forth in a municipal charter or ordinance, the Ethics Commission has repeatedly opined that attorneys in private practice performing legal work for public agencies are independent contractors and therefore not subject to the Code of Ethics, nor are they constrained by the code's conflict of interest provisions. Several examples are cited in the draft. Here, the petitioner's former law firm provides legal services to various school districts as an independent contractor. For this reason, the petitioner did not fall under the jurisdiction of the Ethics Commission when she was employed by the law firm, and therefore is not prohibited by the revolving door provisions from engaging in the representation of clients as described in the draft. I'm happy to answer your questions or defer to our petitioner.
Ms. Pickering, you've had the opportunity here, or rather to read the advisory opinion, if you can. To discuss with Mr. Dishes.
Yes.
You have any questions or comments about the advisory opinion as presented?
No.
Commissioners, anybody have any questions, concerns to raise with Ms. Pickering or Mr. Dishes? Yes, I'll say it now. While we go. First of all, congratulations on all.
Thanks.
But I want to say that whatever opinion we give you here, you understand has nothing to do with your role as an attorney, and which committees you may be able to appear in front of because of your prior firm relationship. You understand the limits of our opinion.
Yep.
Is there a motion to approve and issue the advisory opinion as amended this morning and as presented by staff? There's a second. Motion by Commissioner Ritchie, second by Commissioner Callahan. Roll call vote. Commissioner Susie?
Aye.
Strauss?
Aye.
Commissioner Rabideau?
Aye.
Commissioner Callahan?
Aye.
Commissioner Centerini?
Aye.
Commissioner Rabideau?
Oh, aye.
Commissioner Ritchie?
Aye.
And the chair votes aye. I skipped you again? It's a list. It's a list. Well, Rapidu gets 2 votes. We don't get any. Commissioner Brown. Commissioner Rapidu, take away one of your votes, please. And the chair votes aye. Having made 3 mistakes today, I hope that's the last one. Thank you very much.
Thank you. Nice to meet you. Yes,
Getting stuck in traffic will do that.
All red lights.
All red, and for school buses.
The next one on the list is Karen Ellsworth. And I should indicate on the record this, that I've known Ms. Ellsworth for a lifetime. Back when we were young. No matters what the president. I haven't had conflict with this. The record showed it. We've known each other for a long, long time.
This advisory opinion is in the tab A in your binders. The petitioner is the deputy zoning inspector for the town of Exeter. In her private capacity, she is a legal counsel for the Rhode Island Public Works Association, or short RIPWA. RIPWA is a fraternal organization of state and municipal employees, and its mission is, among other things, to represent the interest of public works. In March of 2025, she was asked by the town solicitor to respond to zoning-related inquiries by Mr. Asa S. Davis III, who is a town resident, because the zoning inspector had a conflict, and that was preventing him from responding to Mr. Davis. Mr. Davis was seeking a zoning certificate related to a property that he owns in town. The petitioner responded to Mr. Davis's concerns without issuing a zoning certificate. However, Ms. Davis would still like such certificate issued. The petitioner represents that Mr. Davis does not believe that the zoning inspector has a conflict of interest that prevents him from addressing Mr. Davis's concerns. And have suggested that if a conflict of interest exists for the zoning inspector based on prior filings against the zoning inspector filed by Mr. Davis, then such a conflict of interest exists also for the petitioner based on a ethics complaint that Mr. Davis had filed in 2022 against a board member of RIPWA. Mr. Davis believes that because the petitioner at that time was legal counsel for RIPWA, that would prevent her from reviewing Mr. Davis's inquiries. That ethics complaint was filed against Mr. Matchcheck. At that time, Mr. Matchcheck was an officer of Ripon, and he was the Public Works Director for the town of Exeter. The petitioner represents that she has been legal counsel for Ripon since 2008. In that capacity, she files Ripon's annual reports and has drafted its bylaws. She represents that she has never attended Ripon's meetings, and to the best of her knowledge, she is not acquainted with any of the members except the executive director. She has never met Mr. Matchcheck, and she was not employed by the town of Exeter when Mr. Matchcheck was employed by the town. The petitioner represents that she did not provide legal representations to Ripon or its officers relating to the investigation of the ethics complaint, given that the ethics complaint was not filed against Ripon, but against Mr. Matchcheck in his capacity as an Exeter employee. She states that her involvement with that investigation was limited to the following three actions. She advised the Ripon's executive director that he was required to respond to a subpoena by the Ethics Commission. And she was being copied as a courtesy on some correspondence from the Ethics Commission with regards to Ripon's bylaws. And she had a telephone communications with Mr. Davis relating to inquiries about whether the bylaws are a public record. Additionally, the petitioner represents that she does not reside in Exeter and does not own property that abuts Mr. Davis's property that is subject to the certificate request. She further represents that she does not have any business associate relationship with Mr. Davis and does not represent any clients in legal matters involving Mr. Davis. The petitioner adds that her public duties relative to Mr. Davis's request for zoning certificate will not have a direct financial impact upon her, family member, business associate, or employer. She believes that she does not have a conflict of interest related to Mr. Davis's request based solely on being legal counsel for Ripon during the ethics complaint investigation against Mr. Matchcheck. However, out of abundance of caution, she is asking whether she can continue to review Mr. Davis's input. Here, as a legal counsel to Ripon, the petitioner is a business associate of that corporation. She is not, however, a business associate of its board members. She did not represent Ripon during that litigation, nor did the petitioner represent Mr. Matchcheck. Mr. Matchcheck is also no longer a member of Ripon's board of directors, and even assuming that there was a business associate relationship between the petitioner and Mr. Matchcheck during the investigation of the ethics complaint, such relationship would have ended at this time. Moreover, Mr. Matchcheck is not involved in Mr. Davis's request to the petitioner. Therefore, it is the opinion of the staff that the petitioner is not prohibited by the Code of Ethics from performing her public duties relative to Ms. Davis's request solely based on her having been legal counsel to Ripon during the investigations. Thank you. I'm happy to answer any questions you may have.
Ms. Ellsworth, do you have any questions or concerns to ask us?
I do not.
Anything you'd like to add to what's been presented?
I'd really like it if I never had to talk to this man again in my life. But, I'm afraid that's not what's gonna happen.
Mr. Richmond, well, can we do that?
No. Might go further with that, but I won't. Commissioners, does anyone have any questions or concerns to raise with either Ms. Papa or Ms. Ellsworth? This did feel like an abundance of caution. Hearing no further comment, is there a motion to approve the advisory opinion, approve and issue rather the advisory opinion as presented by the staff Moved by Commissioner Lucy, is there a second? Second by Commissioner Browner. Commissioner Susie,
Aye.
Commissioner Strauss.
Aye.
Commissioner Browner,
Aye.
Commissioner Callahan. Aye. Commissioner Centerini,
Aye.
Commissioner Rabidou.
Aye.
Commissioner Ritchie.
Aye.
The chair votes aye. Thank you, Ms. Ellsworth.
Thank you.
The last item on our sign-up sheet is Ronald Gonzo, who's waiting patiently in the front row. Step out and get the door on the building. But that might be necessary.
Draft for Mr. Gonzalez is at tab 3 in your binders. Welcome.
Thank you.
The petitioner is the Executive Director of Administration and Finance for the Newport Public School Department. He recently accepted a full-time position as the Chief Financial Officer for the Rhode Island Department of Housing. He requests an advisory opinion regarding whether he is prohibited by the Code of Ethics from, upon leaving his current municipal position and starting his new state employment, then simultaneously working part-time for the Newport Public School Department as its business manager. The petitioner has held his current position since 2019. He identifies among his primary responsibilities the following: preparing and administrating the school department general fund operating budget, overseeing the completion of the final school committee annual operating budget, and preparing the necessary financial reports for monthly school committee meetings. He also directly supervises the daily operations of the Human Resources Department, Transportation Services, Food Service Operations, the non-public textbook program, and performs payroll and purchasing functions. He participates as an integral part of the negotiations for health, dental, and group life insurance contracts, and serves as the school department's risk manager on all insurance matters. He works remotely from 7 a.m. until 5 p.m. Monday through Friday and reports directly to the city's superintendent of schools. The petitioner expects to begin his new employment as CFO for the Department of Housing in May of 2025. His work hours for the state will be between the hours of 8:30 a.m. and 4 p.m. Monday through Friday. The petitioner identifies among his general duties in this position the oversight of funding from the federal government to be dispersed through the Department of Housing and other community service providers, and aligning access programs and funding for those struggling to obtain housing in Rhode Island. During his interview for the Department of Housing position, the petitioner mentioned that he would be interested in staying on with the city of Newport in a reduced capacity, at least for the foreseeable future, so as not to leave the city in a bind as a result of his departure. The individual with whom he discussed this at the state suggested contact the Ethics Commission for an advisory opinion addressing the issue. The reduced capacity in which he would like to continue to work for the city of Newport is as the school department's business manager. His general duties would include the oversight of the general operating budget for the school department, interaction with the Rhode Island Department of Education relative to state aid from federal sources, and the oversight of transactions between the school department and third-party vendors. He would continue to work for the city remotely as he has done since 2020. His work hours would be Monday through Friday between the hours of 6 and 8 a.m. and 5 and 8 p.m. and on weekends as needed. He would attend monthly school committee meetings in the evening and 2 workshops annually. Although the petitioner reports to the superintendent of public schools under an employment contract with the city in his current position, were he to continue with the city as the school department's business manager, he would do so as an independent contractor under a professional services contract and report directly to the school committee. The petitioner represents that the performance of his part-time duties as a contract business manager for the school department would not impair his independence of judgment as to his official duties as a state employee, but adds that in order to avoid even an appearance of impropriety, he would recuse from participating in any housing department grants to the city of Newport. He further represents that he would have no occasion, whether personally or on behalf of the city of Newport, to appear before the Department of Housing. It is under this set of facts that the petitioner seeks guidance regarding whether he is prohibited by the code from, upon starting his new job with the state, then simultaneously working part-time as an independent contractor for the Newport Public School Department as its business manager. Consistent with the code provisions cited in the draft, the Ethics Commission has regularly opined that public officials and employees are not inherently prohibited from holding employment that is secondary to their primary public employment or positions, subject, however, to certain restrictions, and provided that their other employment would neither impair their independence of judgment nor create an interest in substantial conflict with their public duties. Factors considered include, but are not limited to, the following: the nexus between the public official or employee's public duties and the contemplated other employment in which they wish to engage. Next, whether the public employee completes such work outside of his normal work hours without the use of public resources. Whether the public official or employee is to appear before or the work product is to be presented to their own agency. And whether such work is to be conducted outside of areas over which the public employee has decision-making jurisdiction. And whether the public employee uses their public position to solicit business or customers for a private employer. Here, the petitioner describes his proposed duties as a part-time business manager for the school department as being separate and distinct from those for which he will be responsible as a state employee. He states that he would perform his part-time contractual work outside of his regular hours as a state employee and outside of the areas over which he will have decision-making jurisdiction as the Department of Housing's CFO. There is nothing in the facts as represented to suggest the petitioner would appear before or that his work product as a business manager for Newport's school department would be presented to the Department of Housing. Based on the facts as represented, there's no evidence to suggest that the petitioner's part-time contractual work for the school department would either impair his independence of judgment or create an interest that is in substantial conflict with his public duties at the Department of Housing. Accordingly, it is the position of staff that the petitioner is not prohibited by the code from working part-time as a business manager for Newport's school department in the manner described, provided that all of the work is performed on his own time without the use of state resources or confidential information obtained as part of his state employment. The petitioner's intent to recuse from participating in any matters involving housing grants to the city of Newport in order to avoid even an appearance of impropriety is acknowledged and supported. Any such recusal should be made consistent to the provisions of Rhode Island General Laws, Section 3614(6). Finally, the petitioner, who may be the most hardworking individual I know, is advised to seek further guidance from the Ethics Commission if any changes occur within either his private or public employment that could present a conflict of interest. I'm happy to answer any questions or defer to Mr. Gonzalez.
Morning, Mr. Gonzalez.
Good morning.
You've heard Mr. Decius. I'm sure you've had an opportunity to review the advisory opinion and draft for today.
I did.
Do you have any questions, comments, concerns?
I don't. So,
Members of the commission, anybody have any questions? Gonzalez? All I'm gonna say is, if you get some sleep.
Yeah.
Well, how you gonna do it? That said, is there a motion to approve the advisory opinion? Approve and issue rather the advisory opinion as presented by the staff.
so moved.
Motion by Commissioner Rabbit, is there a second? Second by Commissioner Callahan. Roll call vote, Commissioner Susie.
Aye.
Commissioner Strauss.
Aye.
Commissioner Bronner is recused. Commissioner Callahan.
Aye.
Commissioner Centerini.
Aye.
Commissioner Rabideau.
Aye.
Commissioner Ritchie. The chair votes aye. Thank you.
Thank you very much.
Thank you.
We will, it's grateful. No.
All right, the next item on the agenda this morning is the continuing discussion of rulemaking, amending the code of ethics gift rule at Regulation 1.4.2 regarding gifts from registered lobbyists and maximum allowable gift limits.
Sorry,
Direct.
shouldn't get.
Oh, we need. Thank you very much.
That filling out is.
All right.
Thank you.
No, I just. No, it's. Yeah, very much so. A battle buddy has gonna, as I've said all before. You're all here. I'm gonna reread the agenda item. Continuing discussion of potential rulemaking, amending the Code of Ethics gift rule. Regulation 1.4.2 regarding gifts from registered lobbyists, maximum allowable gift limits, presented by Director Graham.
Hello again. So just briefly here, what's in your packet is a letter from Common Cause, which John Marion, the executive director, he's here today. So if you have questions about that, feel free to ask him about that. I'll just briefly note, it appears the letter is just an answer to a question that was raised by Commissioner Rickey in the last meeting as to whether or not this proposed regulation would apply to all lobbyists, including government lobbyists. And it appears that the answer is yes, apply to any lobbyist giving a gift to someone that he or she is lobbying. Leave that to you and Mr. Marion if you want to explore that further. Regarding further matters under this agenda item, I know that I have, promised and perhaps overpromised that I'm going to get you some research on other states. I want you to know that I am working on it. I have completed New England insofar as looking at what the gift limits are and also whether they prohibit gifts from lobbyists specifically, in addition to others. I do want to tell you that it is quite a slog, this particular research project. And the reason being, I want you to understand why. And I've said variations of this before, but every state's code of ethics and or gift rules are completely different. There is no set blueprint for, number one, what an ethics commission looks like in a state, what its powers and duties are, what its jurisdiction is, if it has gift rules, how it's written. And so to try and compare what we have in Rhode Island, which is unlike the gift rule in any other jurisdiction. But you could take Kentucky's gift rule. It will also be different than the gift rule in any other jurisdiction. The same as for Massachusetts and Ohio. So when I'm looking at these things, even just trying to decide what are the gift limits if they have different gift limits, even that is a very difficult process because, for instance, Rhode Island says don't accept a gift worth more than $25. It's pretty simple. Okay, that makes sense. Another state might say, a public official shall not accept a gift of any value whatsoever. Okay, must be a zero tolerance rule. But if you look a little deeper into a different section of their code, you'll find that gift has a definition. And the definition of gift is, except for de minimis gifts, which might be valued at $10 or $15 or $20. Then some might look like they have a very strict gift limit policy. And so, I could report it as, oh, well, this state has a $10 gift or a $50 gift limit. But that's not really the whole story, because then you can see that they have 19 exceptions that completely undo the entire rule. One exception that I see a lot from state to state is, but not in every state and not in Rhode Island, would be an exception for a gift from a personal friend. Which, if you have that exception, you pretty much don't have a gift anymore. Because every lobbyist becomes friends with people they lobby if they do it long enough. It's just, that's kind of that's how it works. So and then as to the question of whether lobbyists are prohibited independently of others, The answer, the broad answer is many jurisdictions do specifically prohibit lobbyists from giving gifts to the people they lobby, but they do it in such different ways. And some of them do it in a code of ethics, and some of them do it in a completely separate set of statutes that pertains just to lobbyists. Some of them prohibit it only during the legislative session, which seems to make sense, except in a state like Rhode Island where the legislative session really never ends, right? It just gets suspended at the end of the session. And so that's a long way of me saying that I will continue this. I definitely would want to explain to you how the New England states vary. And I could do that orally today, but I think it might be better if I do it orally and give you that in writing so you can take a look at it before the meeting and see it. I will continue beyond the New England states somewhat. And then if you want me to go further than that, even I will. But I guess what I'm trying to say is in some respects, it's almost a fool's errand. Because the truth is, and this is just my perspective, someone who's been enforcing this gift rule and was involved in drafting it back in 2005. And also someone who compares our rule to other states when I go to our nationwide conferences, sat panels with other people, is Rhode Island's gift rule is just really excellent. It already is. There's a reason why it doesn't get challenged. There's a reason why everyone already knows exactly how it works. Compared to the gift rules in other states, it's an excellent rule. And so does it need some updating? Yes, I think perhaps it does. I think we should be talking about maybe raising the limit to some. Maybe we do need to close the loophole that John Marion is talking about. You know, at least all these things are worthy of consideration, but whether we do or don't, Rhode Island has a great gift rule and many other states do not. And that's without even getting into the issue of maybe they have a great gift rule, but they don't really have any enforcement mechanism. Or it's a one-man shop, their ethics commission, a one-woman shop, you know, with no investigators to act. And they've never brought a gift case. So that's a long way of saying that's where we are today. John Marion is here if you have any questions about his letter. I assume that you would prefer that I'm happy to talk about some of the New England states today if you want me to, but if you would prefer that I give you that summary in writing at the same time that I give it.
Commissioner Center.
In reviewing the material that's already been presented to us past weekend, the observation that I made was that Common Core through Mr. Merritt, brought up certain points regarding other jurisdictions that may limit gifts, but there was a blending. And the executive director, right, I think has clearly identified it. We were an ethics commission, but when you go back and you look at even the earlier communications from Common Cause, they point out limitations that have been adopted by a legislation. They point out other limitations that exist in that foreign jurisdiction's lobbying. Now, I think to have any meaningful information is going to turn into, for the commissioner, for the executive director, a lifetime's work, because you're going to have to understand the structural lobbying laws of all these different states as compared to Rhode Island. I think we're getting above our skis and making it too complicated to get information that probably is not relevant to us. And I think that there may be better ways for the executive director to spend his time in providing us guidance on this issue. And beyond that, there's a timeliness issue. I mean, to do all these different jurisdictions, what the legislatures do, what the lobbying laws require, we'll be here forever. And, I think we're gonna get caught up in minutia distinctions.
Correct me if I'm wrong, but originally I thought the purpose of your investigation was to provide us with an understanding of what other states' gift amounts were. Is that what we're trying to accomplish? 'Cause
It was a little of both, was my understanding, that I would, while I was looking at other states, I would look at both of those issues. One, and Mr. Marion did provide, I believe he got some research from the National Conference of State Legislatures that provided some information about, I don't remember the specific number, but that maybe 29 states specifically regulated gifts from lobbyists to public. I don't recall that specific number, but it was somewhere in the ballpark there. Of course, they have, paid professional staff. I don't know exactly what the NCSL looked at, but so since I was already going to be looking at limits, I thought, well, let me see if I can add to some confirmation on some of those stats.
And secondly, the New England states, which you proposed as a limited group, would that group still, despite its small size, still be Commissioner Centerini's? Doesn't really matter what they have, and I don't mean to mischaracterize your statement, but it doesn't really matter what they're doing because we have our own here to deal with.
Well, there is a lot of that. I mean, so the Vermont just recently created their ethics commission and had nothing. And they called on me to testify in front of their legislature in support of which I did a couple of years ago. And that's why they now have a code of ethics and gift rules in the first place. I mean, because they looked to Rhode Island, someone who had an established excellent ethics commission, and asked if we could provide them some guidance. So looking to how Vermont does it is nothing against Vermont, a wonderful place, but we shouldn't base what we're doing in Rhode Island with 30-something years of experience enforcing codes of ethics on a state that just adopted a watered-down version of a code of ethics 2 years ago.
So
No, go ahead. No, I'll turn it to you.
Commissioner Centerini's comments and Chair's comments. I'm not interested, but for the gift limit. I really think that's something I would like to see concentrated upon. The rest of it is, Commissioner Centerini pointed out, we're not here to undo what a very accomplished commission has already done and is doing here. Phenomenal staff, phenomenal counsel, everything. I'm not interested in that. I don't see a problem, but I do see an interest in the gift limit. I would really suggest that you limit that discussion and concentrate his efforts in that regard.
If I may, just in terms of a threat, it's the gift limit, and then if there is some level a path to influence, that would be of interest as well. I assume.
So one of the questions before us is whether to bring lobbyists in under the umbrella. And I think one of the things that the director has been also trying to do is to figure out how that fits into the overall picture. But I wonder, at this point, we have, from Mr. Marion, correct me if I'm wrong, a proposed regulation, correct? Correct. I want to ask the commission, do we want to wait to hear more from Executive Director Grammett and his staff? We want to tee this up for the next meeting to actually make a decision on this issue. I don't think we want to tee it up for today. I don't. Is because I wanted to know whether we were going to get more information. Then Commissioner Centerini is suggesting, I mean to characterize, but he's suggesting we don't really need additional information. We know enough. We know who we are. We know what we're trying to do. If that's so, that it may well be that the simpler thing is simply to move this with the intention of taking it on at the next hearing, next meeting. That makes sense to the commission as a group?
Can I get clarification? When you say take it on, take on what? Are we take on a change to the interested person definition? Are we taking on a change to the maximum? What are we taking
That's a
on?
very good point, because they're two different things.
Yeah.
Well, no, they are, because they came from different places.
Okay, so it's still a composite, not
But the issue of adding lobbyists, in a sense, is independent of the amount. So you're right. So maybe what we should be teeing up for next time is the question of adding lobbyists, which is the Marion question.
Thought in our last meeting, and I would defer to Mr. Marion, that in response to my question, I thought Common Cause had moved away from the request of including lobbyists per se. I thought that they had modified their request. Right? That's,
I understood it that we, I'm sorry,
Go ahead.
that we had, talked about it and decided that, you know, lobbyists would be included for those areas that they lobby. So if they're governmental, if they're, you know, if they're the executive branch or just General Assembly, not outside. So like, if the lobbyists lobby the General Assembly, but not the court system, then they would be, so that,
That's,
following that?
I've reviewed the language that over and over. I should have included it again in today's packet. I'll make sure that whatever language we have is always in the next packet. But initially, I think the broad outline from Common Cause was, let's make gifts from lobbyists prohibited to public officials. And the newer understanding is let's make sure that all registered lobbyists are considered interested persons as to the people or entities that they're lobbying, but only. So what Commissioner Susie said, that if I'm a lobbyist and I'm lobbying the General Assembly on a minimum wage bill, for instance, then I'm going to be I'm going to have to follow the gift rule as to members of the General Assembly. But if I have a friend who's a judge or a friend who works at the Ethics Commission, then there's no gift limits or penalties, because there's no interest in between the two. So it would just apply the gift rule to lobbyists and the people or entities that they are lobbying as part of their registration.
And the draft we have before us has made that adjustment.
Yes.
and regarding the other point of nonprofits, what are we talking about there? That, you know, there's been a suggestion, I believe, from Common Core, that area has to be tightened up.
in my,
And that does, so their most recent submission does make it clear that this applies to all registered lobbyists. And it doesn't differentiate between for-profit lobbyists for for-profit businesses, lobbyists for nonprofit organizations, lobbyists like me for a government agency. The point is that they're saying, if you're a lobbyist, you shouldn't be allowed to give a gift over the gift limits to anyone that you're lobbying, regardless of whether your client has a financial interest in that bill that you're lobbying on, or it's a philosophical interest, like it's Common Cause lobbying to get early voter registration. There's no financial interest there, but they still are lobbying the speaker and the Senate president and others. And so Common Cause is saying we shouldn't be allowed to give expensive gifts to these people that whose minds we're trying to change.
but again, it's a Common Cause's position. This is restricted to the General Assembly. That's the question I have.
No,
That's the concern, when I raised that question to Common Cause regarding the judiciary. I think it's getting a little far afield here. I'd like to see a more narrow scope. If we can.
let me suggest it this way, Commissioner Ritchie. I believe we have in front of us a draft amended rule that carries all of the present requests that Common Cause has made for us to consider, and I emphasize consider. Is that a fair statement?
I believe so. Yeah.
Is that a fair statement, Mr. Marion?
Yeah, sure, just throw the camera.
Feel free.
Yeah, no, I mean, I sometimes have to watch.
Yeah.
Eight, and I wouldn't want to say we weren't being transparent. Yes, so we sent a letter on March 18th. With that letter was proposed language. We have not, since that March 18th letter, proposed amending that language. We think that language captures both the original intent per proposal, which is to make sure that lobbyists are covered by the gift rule, and we also think that language takes in the feedback we heard that but only if it applies to people they are lobbying or entities they are lobbying. So it doesn't implicate gifts from a person who happens to be a registered lobbyist, happens to know somebody part of government covered by the code of ethics, that has nothing to do with their job as a lobbyist.
And you feel that in the draft you presented us at this point, those concerns are adequately set forth and covered?
Yes, and after the last time I appeared, there was the commissioner's question about does this cover government lobbyists? And the letter you have before you today, our conclusion is it covers government lobbyists. So we think this is, sufficient. It covers our concerns, it deals with our concerns, and we think it addresses the concerns we've heard from the individual commissioners about tailoring it more narrowly.
So to my fellow commissioners, first of all, I think we're gonna put the dollar value aside. So I think that's a separate issue. My suggestion would be that we take up at the next meeting the draft that we have. And we discuss that draft, and the concerns you've raised today can be discussed in that context. We're not bound by the draft whatsoever. We make our own regulations, but it's a talking point to start from. And so from my perspective, that might make the best sense for our next meeting as an agenda item. Of course.
My personal preference.
Yeah.
Would be to take on the elephant. Move ahead. Let's do the gift limitations at the same, as part of the same process. I mean,
That's fine. That's why I opened the door. I want to hear what you want to do. Well, Commissioner Callahan.
I just philosophically, is there language that addresses the onus of the receiver of the gift? Whereas none of us are required to take a gift. Like that's like, I know in my role now and in my past, like you don't take the gift. Like in this sort of seems to me as a layperson that we are, not that we are excluding the responsibility of the person that would receive the gift, but it doesn't seem that it's explicitly sort of detailed in the same manner. I don't know if that makes sense, but we're saying, hey, Mr. or Mrs. Lobby, you may not do this, potentially, by the way, potentially you may not do this, but yet the onus does seem to be on the public official or, under that broad definition, who receives it. No one's required to receive a gift.
Yeah, and welcome.
Thank you. Yeah,
last meeting.
sorry about that. Crazy question.
And
Yeah.
Thank you for trying to get up to speed on this.
Yeah, I'm trying.
Talk to you about our earlier submissions. The code, I'm sure Jason can correct me here, the code of ethics applies to public officials and employees. And you enforce it on public officials
Right.
and employees. So it would be the recipient of the gift, not the giver of the gift that you would apply this to. And that has been how the gift rule has been
Right.
existed since it was created. And so we're not proposing any change to how you apply the gift limit. We are just trying to say there's a class of individuals who should be subject, whose gifts should be subject to the gift
Okay.
rule, and that class are registered lobbyists as it applies to those they are lobbying.
All right. So I guess I was just reading through the believes that no lobbyists, whether representing private, not profit, or profit companies, should be providing gifts.
Yeah.
So this kind of was, I sort of assumed I was leaning that it was in the lobbyist's domain to make that decision.
Yeah, thank you.
I know it's not either.
No, that's a great point.
Okay.
Great point. I could be clearer there.
We don't have jurisdiction to impose discipline or sanctions upon lobbyists. That may well be in the Secretary of State, who administers that law, or if it be prohibited by the lobbyists, then it'd be the Attorney General or whoever. So I don't think we can directly reach the responsibility of a lobbyist. I agree with Mr. Marion. Our authority under the state constitution are public officials and employees
As recipients.
as recipients.
That's really where the gift rule comes into play. If there's a violation, then we take control on that aspect. That's why I think your point is well taken. Let's bring the gift amount in with everything else. Let's get this thing going as soon as we can.
Yeah. So what I'm hearing, if I can, from the chair, and then is the consensus is, and just to throw a little bit of what the rulemaking process would be and what could happen at the next meeting. What we could do is we could tee up both of these issues for the next meeting for further discussion. With actual draft language, we'll bring back the language that Common Cause has offered. I will put together another draft that has some kind of proposed increase, which it could be, we could just leave it blank, the numbers, and we can fill them in as you decide what the appropriate number might be if you're looking at an increase. But I think we're all talking about in the $50 range, probably, something like that. And we could bring both of these before you. And the only vote that would take place would not be to enact these into law. It would simply be, let's start the formal rulemaking process. You can still vote no down the line. That doesn't mean either of these are going to become law. It just means that you're authorizing me to start the formal process, which will involve providing public notice through the Secretary of State's office that the commission is now considering formal rulemaking. We'll schedule a future date for a public hearing, solicit public comment, and provide copies of the drafts. Or you could vote no, that we're not going to go into formal rulemaking, and that's it. We'll have a nice summer. But either way, we'll have a nice summer. Rulemaking is not a heavy lift. It's kind of fun.
I just, for the sake of the record, like to give fair notice. It's the Common Cause and the executive director. In my review of the material, I go back to January 28th when the executive director gave us guidance in the first instance about the rulemaking process. And when we get to our next meeting, if that's what we're going to do, I think we should consider the three questions he posed to us as the evident, to make a prima facie case to move forward. That, that being that there should be some degree of findings that there's a need potentially for the regulation, that the proposal is the least restrictive, and that it's financially feasible. So I think that flows through the whole process.
Let me ask, is that a precondition to our saying yes to move forward?
It's not a precondition to starting the rulemaking process, but at some point, the staff will have to conduct a regulatory analysis that it'll give to you for your approval. And, in that, we have to weigh the costs and benefits of the rule. We have to demonstrate that there aren't alternative approaches that are equally effective.
So before we reach any formal rulemaking, actual rulemaking, if we decide to go forward, we would have that before us to, or would we have approved it beforehand?
At the point where you finally decide that you want to vote to adopt a regulation, part of those votes will likely include findings of fact. You know, do we find that there's no alternative approach that would be equally effective? You know, you might bring that into the vote. And
Isn't that after? I mean,
that's at the end.
well, again, I think Commissioner Sandy proposed laying a foundation, which is the proper thing to do. Before we get to that, we have the opportunity to say, no, we're not gonna go forward, never reach that. I think Commissioner Sandy is saying, these three aspects have to be before us, we'll make a decision. And then we can decide we're gonna go forward, then I think we come to play what you just. So it's a two-step process here.
That's part of the rulemaking process. So as we have public testimony and as Common Cause steps up during the formal rulemaking process to give its pitch, you know, one of the things you're listening for is Common Cause making, you know, or other proponents in favor of it, you know, explaining why there's a need for this rule, why it's cost effective, why there aren't less restrictive ways that could accomplish the same thing, which is closing the lobbyist. There is a lobbyist. And that will come out through the written public testimony and the oral public testimony, or it won't. And if it doesn't, then you will probably vote to not go to close down rulemaking at that point, and we'll be done. But if you feel satisfied that the testimony and the research and everything else we've discussed shows a need and shows that it should be adopted, then you'll vote to adopt the regulation.
Sure.
But those issues are supposed to come out through, that's why it's a public, transparent process with public notice and hearings and solicitations of comment. And we should get comment. I mean, listen, we'll ask the General Assembly. We'll send a notice to the General Assembly and ask them to, you know, send someone down here to give us their opinion as to whether they like this new rule. We could send something to the Rhode Island Association of Lobbyists. Would you guys like to come down and make a?
We had this discussion before. And it's understood that it would be an effort to reach out. I'm sure it would be a common cause to make that effort to reach out. Constituents or to listeners, readers, and any other interested group of the group that's affected by this commission. So that's gonna be a time consuming, depending on how many people here before us, either in person or in writing. Then we have to digest that as well. It's gonna be a time
We
consuming.
understand that's not for the next meeting.
No, I'm saying, but to get to the point where we're gonna make a decision to go forward, that's gonna be, fair warning, that's gonna be a time consuming process.
Quick question. Did we have consensus that the executive director does not need to continue looking at other states? And wasn't sure if that was clear.
I could use a little clarity on that too. Or was it that you want me to continue looking at amounts
Well,
and adding that to the?
I just wanted to add, years ago, I was working with a colleague on a textbook, and one of the things we decided to do was to not look at the other textbooks, because we knew if we did, what we write is a textbook like everybody else had written. So that's just my analogy for why I don't think even what's happening in New England is necessarily helpful to us. I'm afraid it might muddy the issue, and I think that we should look at what we want to do. And I don't see it, you have a lot of other things to be doing than trying to figure out how to clearly tell us about what other states do that frankly, I'm not interested in.
I can make a motion.
Before you do that, I'll just say, Commissioner Centerini, are you comfortable with the idea of bringing the whole thing before us with the model rule to start the discussion?
When you say the whole thing, you're talking about the limitation to
The
the 25,000? Yeah,
What's your expression? elephant in the room.
Yeah.
The elephant in the room.
Could you put that on the agenda, please?
The elephant.
The elephant.
So, I guess the question is, do we need a motion to continue this matter on the agenda?
I think we need, again, Commissioner Soucy's point. What do we want to direct? Direct,
That's not really a vote,
well,
right? That's an
well,
issue.
okay, but let's,
I think we have a,
That's
there's
what's looking for.
consensus.
I think maybe we have a consensus on that. I don't want to speak for everybody. If you want to do that by motion, we can do that by motion. If somebody wishes to make a motion.
I would
No.
I would move that the director, his efforts be restricted to the gift amount limitations and nothing else. In terms of what. In his review of other states, other jurisdictions, that his investigation be restricted solely to the gift amount.
Is there a second?
I can't second that because I don't think it's clear what other states are. They're
He's gonna
it's
find
not,
out.
it's not what I was looking.
But what if we ask the executive director for recommendation on the amount?
Yeah.
Based on his research. We don't need the research. He can just, he can limit to what he's done to date.
He's gonna know, he's gonna tell us exactly what the figures are. Expect, so, whatever.
Point of clarification, I guess, is, as opposed to other states, is it fair to assume that when the numbers were, this is the costs involved, the gift, the pricing, whatever that number was, and how it was decided back in the day, is it simply appropriate to apply a cost of living increase and not have to call California, you know what I mean? So or some methodology that makes that there's an appropriate increase based on the value of what the dollar was.
Absolutely. Let me respond to that because it was before your time. One of the first presentations we got, from Executive Director Graham, was exactly that question. He had gone and found whatever the historic adjustment was along the years. I think it made it to $42 from the 25, is my recollection.
Yeah.
But I think there's also the question, do we simply look at the 25? What was the 25 based on? Probably just a number. And do we pick a number? But I think the question right now we have, of course, is a motion to instruct the director and his staff to basically simply provide us with numbers, comparative numbers to the extent possible. And I heard from Commissioner Graham that doing that itself isn't easy because you'll get a number here or no number at all. And then later on, there's a number somewhere or a lesser number.
Clarifically, are we talking though, looking at just other ethics laws or lobbying laws or legislative rules? I mean, because then it gets very.
Again, I think we're looking at least from this perspective, a number. What are the numbers? Whether it's a lobbyist gift, a legislative gift, an an ethics commission gift, we still should have some sense of the number. I think that's really what Commissioner Ritchie's looking for.
Yeah, I think that to respond to Commissioner Sereni, it would have to be a commission, ethics commission ruling, not legislative, not judicial, us, because again, the advisory opinion in 1991, 1992 gives us jurisdiction, not the legislature. So I would suggest under the circumstances, I'll restate my motion if I may, basically.
There was no second, so feel free.
Yeah, thank you. At the director, be authorized through the staff to investigate the other ethics commissions throughout the country have developed or established in terms of gift limitations and report back to us those findings along with a recommendation from staff and the director.
I have a comment.
See, I don't think all of that is necessary. I know you didn't ask for discussion on the motion.
Well, there isn't a second yet.
Okay. I just, I.
We need a
We have legal counsel make the motion. This is
We need a
No,
second
no,
for discussion.
Yeah, for discussion.
I'll second it for discussion.
All right. Discussion.
So
Commissioner Revenue.
I don't think all of that is necessary to put on the executive director. I think he's done an amount of research, and I think with that research, he should be able to provide us with a recommendation for an amount, even if it's just, hey, this is our baseline, this is our cost of living over the last so many years with the baseline, and to quote a term from my profession, we want some freeboard above it, to make sure that we're able to carry it forward.
Other jurisdictions, I want to know what he found in other jurisdictions before we make a recommendation.
See, I guess I don't care what North Dakota did.
Well, no, again.
You know what I mean? No, it's not the same
I,
economy, it's not the same
Geographic.
geographic location. It's just different. It's
but again, I mean, there has to be a base for this.
Commissioner Ritchie, let me ask it this way. Are you suggesting we give him the discretion to do the necessary work he feels to present us with information that he feels is necessary for us to be able
Yes,
to make that call?
yes.
And I don't think we need a motion.
No,
for that.
I think the executive director just needs some direction.
That's what I was looking for.
So I'd ask, Mr. Ritchie, would you withdraw the motion?
I will withdraw, of course, we're not gonna go back to the directions. Let's hear what the directions.
He knows what the directions are.
He knows?
I can summarize it, I think, to everyone's satisfaction. I think what I'm hearing is you would like me to come back at the next meeting. Having looked at other jurisdictions, having looked at the rate of inflation based on the consumer price index to see what $25 then looks at today. Having taken all this into account, being prepared to discuss some of these exemplars from other jurisdictions, and I'm happy to do not 50 of them, but maybe a few that show the range of what we're dealing with. And based on that, to tell you the range of increase, if any, that I and the staff feel comfortable proposing to you to consider.
That sounds.
And also to meet common cause's concerns, whether the interested person definition in our code should be modified in any way.
That's part of it, as the common cause motion or petition.
I can also be prepared to give, to the extent that, ultimately, it's your vote as to whether to do any of these things. So my opinion as to whether their proposal is good or that's just information for you to use. But that's all it is. I'll be prepared at the appropriate time in the next meeting to tell you how I feel that common cause proposal would impact the gift rule, our regulation, our enforcement, whether it would be a benefit to our.
And again, we presently have the common cause final draft that we can look at before the next meeting. Correct.
Yes.
And would your intention be to provide us with anything in writing on those issues you discussed, or simply to go before us and give an explanation?
I think let's separate it out. So as to the.
I'm talking about the number here.
Oh, as to the numbers. Well, I'll ask what you would prefer. If you would like something in writing that has a recommendation and it summarizes the things I said, a small comparison of some of the ranges and also the rate of inflation, I'd be happy to put that in.
I personally would like that,
Yeah.
This is what you think is appropriate.
Do that.
So the public like to know what other states have done,
Right.
how we reach that conclusion.
We'll see
We can't do this
We'll see
blind.
what he can give us.
Yeah, I can do that.
Just do it.
I know we already have the proposed rule from Common Cause, so I won't ask you on that one. But I would ask you if there's a possibility for at least that piece to be circulated before the Thursday before our meeting.
Yeah.
I know you're gonna be operating under some form of a deadline, but some of the more substantive stuff I find difficult to really take, assimilate, and bring to a meeting on 4 days.
Let's not restrict them then. Let's give them time.
Bring it,
It could be done 2 months from now. So I don't see the big
I think we want to take up, unless I'm mistaken, I think we want to take up at the next meeting. the
I think
preliminary.
your point is well taken. It may be too much to accomplish. That's all I'm saying.
Well, I'll leave that to the executive director.
What is it, you're saying that you would like, which part would you like earlier than the Thursday?
If what you're gonna give us is, I think the proper range is, 50 to 150, then that's not really particularly significant. If you've done a little bit of a study and are gonna give us a basis for it, I'd just like to read it a little bit more early than the Thursday before. Meeting when we get our packet, if that's an acceptable method under the open meetings law. If we're not supposed to receive information before the public notice goes out, then that's fine, we understand that, but there have been a couple of times where it would have been helpful to me, I don't speak for anybody else, to have had it earlier so I could fit it into the rest of life.
Yes.
There's no restriction on getting things early under open meetings law, so that's not a problem. It's really just a question of when I can get it done. And I assume that I can get that memo that I'm envisioning as we speak and that you're asking for. I assume I can get that done before everything else that goes out on Thursday. Advisory opinions and things like that, we're still writing them Wednesday afternoon, which is why we sometimes have to do edits right here.
Right.
Restrict.
Right.
It would be a draft. So that's-
And I think I can accommodate.
So. You withdrew your motion,
I
correct?
did.
Yes, you did withdraw. I asked him. I asked him for that before. So there's no motion on the floor.
Okay.
Again, I think, and I speak for everybody, but I think the consensus is to take this issue up at the next meeting, or call it issues, but the rulemaking process of gift amount and whether to modify the gift rule to capture others. Let's use that expression for now. Is that the consensus we have here? And I'm gonna start with Commissioner Centerini. Is that what you're looking to do?
I agree with your concise summary.
All right. Is there a consensus on that around the room? Sir. I don't think we need a vote then. I think it goes on the agenda. You circulate the materials. Commissioner Ritchie, if you care to motion, I'll let you try. You tried twice.
Judges don't make motions. That's
Probably a good thing.
for sure.
All right, the next item in the agenda is a motion to go into executive session, to wit, a motion to approve minutes of the executive session held on April 8th, 2025, pursuant to our general law section 42-46-5A, 2, and 4, and then a motion to return to open session. Is there such a motion?
Well moved.
There's a second? Second by Commissioner Susie. I'm gonna do a roll call vote on this. Commissioner Susie.
Aye.
Mr. Strauss.
Aye.
Mr. Browner.
Aye.
Mr. Callahan. Mr. Centerini. Mr. Rabideau.
Aye.
Mr. Ritchie.
Aye.
The chair votes aye. We're now going to executive session.
This should be a pretty brief executive session, and then the open meeting and live streaming will reopen after. Moment.